All right, it's just about 11 a.m. and we are trying to stay on track here. So I want to take a minute to thank our sponsors, Leadstone and Franklin Outdoor Advertising. And I want to hear from our one of our sponsors, Quinlivan and Hughes. So I am going to pull up their video real quick and we'll go ahead and chat.
Hello, my name is Melinda Gao, and along with being an attorney, I serve as the CEO at Quinlivan and Hughes Law Firm. Quinlivan and Hughes is proud to be a sponsor for the online Farming Today conference and is also proud of the two attorneys who will be presenting to you. Attorneys Kirsten Erickson and John Wenker will discuss ways that you can provide protection for your family and the assets you've worked so hard to build. At Quinlivan and Hughes, we have been an active member of our local community for over 95 years. We proudly serve individuals and businesses throughout the state of Minnesota. Whether you need forward-thinking estate planning, practical employment solutions, strategic business advice, or a strong legal advocate to guide you through the litigation process, we have a team of attorneys ready to listen to your specific needs and help you achieve your goals. Please call us at 320-251-1414 or visit us online at www.quinlivan.com for more information.
Want to introduce our very special speaker. It's 11 o'clock. Can't believe it. The day's going so fast. You're with Farming Today. And I want to please help me welcome Kirsten Erickson. She's an attorney with Quinlivan and Hughes, PA. The name of her presentation and the topic that she brought to us today is What Are Your Wishes? A discussion on some basic estate planning tools and what happens if you do not have any planning. So go ahead, Kirsten, and take it away.
All right, well, let me see if I can get my screen shared. So again, my name is Kirsten Erickson. I'm an attorney with Quinlivan and Hughes. I do have several slides today, but it's also meant to be interactive. So if you want to jump in with any questions, don't hesitate to interrupt me. I'd be happy to hear them. And again, this is also a general presentation. So there may be facts that are specific to you that might, go beyond this presentation. But it's really a great tool to get an idea as to, how do we make sure that our end of life goals are accomplished. So why plan ahead? Well, there really are, there's several advantages, but two that I'd like to point out today is you're in control. You're not letting Minnesota statute decide where and how your assets are distributed at death. And then the decisions that you make ahead of time also makes it a lot easier on your loved ones. Some basic estate planning tools are, wills and trusts, I think common buzzwords that a lot of people are familiar with. Also some basic estate planning can be done through deeds, so how do you own your real estate? Are you married? Do you own it as joint tenants? Or have you done a transfer on death deed? And then beneficiary designations. A lot of times, people are able to accomplish their goals even without the need of a will. So when you're looking at how do you accomplish your estate planning goals, it's more than just having a will or a trust. It's really looking at what are your assets and can we link them to someone directly at death. So why make a will? It's going to coordinate the disposition of your property. It avoid intestate law. So intestate is kind of that buzzword that means, what does Minnesota statute say? How your assets should be distributed at death. It provides for changing circumstances. You can also make charitable gifts. So if that's a goal of yours, that doesn't happen naturally by Minnesota law. You do have to directly make sure that gift is accomplished either through a will or a beneficiary designation. It also names a personal representative or a guardian. So if there's someone that you want to be in charge of your estate, that's the personal representative, and that person's named in the will. And also a guardian. So if you have minor children, and if you and your spouse or a parent of that child are both not living, who do you want to take care of your children? You can also, in a will, you can create a trust for your children. If you don't want minors or even 25-year-olds to receive a large sum of money outright, how do you want that money to be managed? And then also tax planning. In Minnesota, there are some estate tax consequences above $3 million. And that also includes your life insurance policies, your real estate. So you might need to consider some tax planning as well. And so these are all reasons why one might look at doing a will. What wills do not do. So a lot of times I hear from clients, they want a will so they can avoid probate. Wills do not avoid probate. Wills are actually kind of the roadmap for probate. And probate's not necessarily a bad thing. It just means that there'll be some court oversight, and it may delay or limit access to assets immediately. But it's not necessarily a bad thing. Wills are also not powers of attorney. So while you're living, if you want someone to manage your finances, if you no longer have the ability or the capacity to manage finances, a will won't take care of that. You need a power of attorney as well. And the other thing is, wills do not take effect until death. So, you can do whatever you want with your assets in your lifetime, regardless of what your will says. The will controls at death. What is probate? So when does probate apply? When you need an initial hearing to have a personal representative appointed, when you need to take care of the administration of an estate, and then probate at the very end, you may need to file something with the court to close the estate when all the assets have been distributed for the terms of the will, or intestate law, I should say as well. How long does probate last? It kind of depends on the complexity of the estate or whether family members are getting along. Typically for a formal probate, which means that the court is formally appointing a personal representative, from the date of filing, we might see a hearing date anywhere from 6 to 8 weeks in Stearns County. And that's pretty common in other counties as well. The nice thing about a probate is if everyone's getting along and you're not in Hennepin County, Anoka County, or Sherburne County, you don't actually have to attend that hearing. So even though there's a formal court process, it might just really be submitting paperwork for the judge to sign off on. But some probates can last 2 years or longer. So it really depends on how the parties are getting along and what assets are there, and if it's as simply easy as deeding it to someone's name, or something needs to be sold through the probate process. How much does probate cost? Again, it varies on whether family members are getting along or not. Typically, it costs between, I would say, maybe $3,000 and $6,000 if parties are getting along. And then it can be significantly more if people are not getting along. The personal representative, though, they're not personally liable for the cost of the probate proceedings. That is paid through the estate. So the decedent's assets will cover the cost of legal fees or accounting fees or any other administration costs in a probate. Some advantages of probate, it works well for simpler estate plans. Especially for individuals that may be looking to, leave everything to a spouse, and then, if the spouse isn't living, split it equally amongst the children. It also may simplify financial affairs during the lifetime. And then there is that added protection with the formality of probate. Maybe it's good that the court has set deadlines for when creditors or families can raise disputes. So court, again, is not always a bad thing. Some disadvantages of probate: there's a slower distribution on death, a little bit lack of privacy, given that the will becomes a public record. And then also in your petition to the court to have an appointment of a personal representative and a probate of a will, that petition will also include asset information. So people who are looking to have a little bit more privacy may not want the probate process. And again, it may be a little bit more costly than maybe a trust administration, or if you had named a beneficiary directly on an account. Now, that being said, maybe there's a lack of privacy, but I don't know how often people go to the courthouse to look up wills or read petitions. Certainly when Prince passed away, a lot of people are following that probate administration, but that may not be the case for most individuals. So some methods for avoiding probate. Again, joint tenancy on your deeds. What that means is if after one person passes away, the joint tenant automatically owns that property in their name without the need for probate. Life estate deeds. So an individual could retain their interest in that real estate during their lifetime, and then at death, it would automatically pass to the individual named on the life estate deed. You can also do this with a transfer on death deed. The transfer on death deed can be a great tool in it that it doesn't change your ownership during your lifetime. So if you want to sell the property, you can get a second mortgage on that property. You don't need the permission of the beneficiaries that are on the transfer on death deed. Again, beneficiary designation you can do with retirement accounts, investment accounts, but you can also do a payable on death for your bank accounts, which is also listed on this list. And that's a form that you just go with your bank, and they should allow you to be able to complete that. And then additionally, multi-party. So whether you own that with someone else, some people look at owning bank accounts with children or spouses, which are a way to transfer that property without having to go through probate. And again, a trust is another option as well, which leads into what is a trust. This is a private contract which includes instructions for distribution that can be carried out without court supervision. So the trustee holds the property for the benefit of the beneficiaries. And there are various types of trusts. So testamentary, that means a trust that's established in a will. So a testamentary trust, you're not avoiding a probate there. We've got revocable trust, which means you can amend it and change it during your lifetime. An irrevocable trust cannot be changed during your lifetime. You can also set up trusts to protect your children, maybe help manage, have those assets managed for that child. There are certain types of trusts that you might do for individuals with special needs. There may be a reason why someone shouldn't own assets outright. It may change their eligibility for certain government assistance. And so we want to make sure that those people can still receive that special assistance, but then have that trust for their benefit as well. People also look to do trusts to save on estate taxes, and then also trusts to help protect assets from creditors. And again, there are also trusts that people may create for the benefit of charities as well. So an advantage of a revocable trust, this also will avoid probate. It maintains that privacy because you don't have to file anything with the court with a revocable trust. The revocable trust becomes irrevocable at death. So at death, no more changes can be made. And they don't have to file the trust document or asset information with the court, unless the beneficiaries wanted to resolve a dispute through litigation. It really does remain private. And then the trust also helps deal with asset management. There might be planning for incapacity, which is another great tool if someone loses the ability to manage their assets for themselves, whether it's let's say a dementia diagnosis, or they just really don't want to deal with asset management anymore. Their trustee can be the one to take care of that. And then also charitable planning. It's a way to name multiple charitable organizations if that's something that you're interested in. But there are some reasons why maybe revocable trusts may not be appropriate. Sometimes it complicates ownership. There might be, you spend more money up front to have a trust created. And then there are no formal procedures for disputes with claims, creditor claims, as there is with probate. So depending on how children or other beneficiaries react, they may still bring it into court. Something that I don't have a slide on that I kind of wanted to touch base as well is, well, what happens if you don't do any planning? The way that Minnesota law looks at this is, if you don't do any planning, if you're married, your assets go to that spouse. If you're married and also have children from another relationship, assets are split between the spouse and those children. And there's some specific rules. Certain assets would only, the spouse is only eligible to receive. And if you are not married and have children, it would split equally amongst those children. And so there are reasons to do a will or a trust, even if Minnesota law does what you would want it to do. Part of that is, well, what happens, who's in charge? Well, maybe there's one child or spouse or a relative or friend who would be better at managing the estate and taking care of that. And so that's why you still might do a will, even if Minnesota law does what you want it to do, just so you can make sure the right people are in charge. Additionally, if you're not married or if you don't have children, what Minnesota law is going to do is it'll say, well, okay, then it goes, your estate is split equally between your parents. And if your parents aren't living, then it would split equally amongst siblings. And if a sibling had passed away, that sibling share may go to nieces and nephews. So it goes down that family tree. And so depending on your relationship with your family or the size of your family, that might not be what you want either, which really does make it then important to make sure you're doing some sort of planning. Now I know I've just kind of gone through a lot so far. Are there any questions that people have? Well, and let's see, why don't we go back into, we can kind of go into, since we've just briefly skimmed through some of this, a lot of times trusts aren't, I think there used to be this myth that trusts are for those people that have billions of dollars. It's really only to deal with estate tax, and that can be a piece, but sometimes people look at trusts because, some of the tools that we have, like a transfer on death deed, it's, using that to transfer real estate to, let's say your 5 children equally. That doesn't always work well, because in the state of Minnesota, once you can't sell real estate without the consent of a spouse. And so if those individuals are also married, you might be looking at, your 5 children plus 5 spouses trying to work out a deal on the sale of the real estate. So someone might still do a revocable trust to say, at my death, transfer my real property to my trust, and then the trustee can work on the sale of that real estate and then distribute it to the beneficiaries. Additionally, if the individuals that you want to provide for at death are friends, you might not want friends to be co-owners of real estate. So you wouldn't necessarily want to use a transfer on death deed for that purpose either. So depending on what your goals are and who you want to provide for at death, sometimes trusts actually are simpler than working with a will, because it puts one or a couple people in charge, the trustees, to take care of paying off all the bills from the estate, and then distributing the assets. And then another thing is, if you don't have loved ones that you would want to be in charge of the administration of your estate, you can also look at having professionals be in charge as well. And I see I just had a question. If I have children's named on a savings account, does that make the account vulnerable to bad debt or legal issue children might have? So I guess when you say bad debt, do you mean like the current owner's debt at death, for those assets may have to pay bills, or do you mean, if the children have creditor issues? And the way I would look at this is, so if the children have creditor issues, well, yeah, so once you pass away and the asset then is distributed to the children, and it's in their name outright. So if they have creditor problems or money management problems, that asset could then be subject, to payment of that. And so if you want to preserve that or protect that for the children, that might be a case where you would do a trust child. And so, your will or your trust doesn't have to say, an equal share to my children. You really could say an equal share to my children, provided that, each share is held in trust for the benefit of such child. And then you can really work out the terms and conditions if you believe that protection is necessary and important. And that's kind of another layer of planning as well. At death, you might think, let's pick on, let's say, the oldest child or your accountant friend. Those are the people that you would want to help deal with the administration of the trust. But if you're establishing maybe a trust for a period of time for a child or a friend, or for life for that individual for that matter as well, who do you also want to be managing that? Do you want it to be a professional company, or would you want it to be an individual? And there's pros and cons to both. Or professional representative, now they will charge a fee, but maybe that's worth it so that siblings don't have to manage trusts for each other. Another question is, what suggestions when asset owners have different priorities? So if we're looking at, an asset, and I'm assuming, let's say, a couple, and maybe the couple has different priorities. Well, when you own it jointly, there's that survivorship benefit, so it'll automatically go to the surviving spouse, and then that surviving spouse, because they own it outright, they have the ability to determine how that asset is spent or used or saved. So if someone would like an asset to be preserved, that's where you might look into doing some sort of trust planning, because that asset could go in trust, first be in benefit for that spouse or that co-owner who has maybe a different priority. So at least there's that protection of somebody else managing that asset, and then preserves it for after that surviving co-owner dies, to go where, wherever you'd like it to go. But the important thing is, when you're co-owners, you kind of have to get on the same page to either put that asset in a trust, or maybe decide to split it up. So then if you have different priorities, each of you can accomplish your own priorities. Although certain assets can't necessarily be split either. And there may be pros and cons to doing that. So that's why another piece of, your estate planning is really pulling in your financial advisor too. And so they can also say, because an attorney can tell you legally what you can do, and then the financial advisor might look and say, well, it doesn't make sense to do it this way, or there's an advantage to doing it this way. And just like bringing the accountant in as well to say, what makes sense with the tax planning piece as well. So another follow-up question, what factors drive costs of probate, attorney's fees, court fees, value of the estate? A lot of times it might be the type of asset in the estate. Like, for example, I'm working on a probate and there's a resort as the asset. And it's actually almost entirely the main asset. So it's valuable because the resort property is valuable, but there's not a lot of liquid cash. But it's a more difficult probate because the personal representative is now also running a business. So maybe questions, such as how do I do an independent contractor agreement, are coming up in that probate that really aren't common in other probates. So attorney's fees really vary too, also based on how much involvement the personal representative wants. The personal representative is entitled to an attorney, and those fees can come out, reasonable fees can come out of the estate. Some personal representatives are only looking to really have the attorney prepare some of the court documentation. And then from there, the personal representative will deal with selling any real estate or combining any bank, things of that nature, paying any bills. And the personal representative is comfortable doing that on its own. So that might minimize attorney fees, and then also court fees, because there's less filings that need to be done with the court. But really I think the major factor with the cost of a probate has to deal with, aside from, if there are unique assets in that estate, but also, are the parties getting along? All the beneficiaries. That's why if individuals, up front, it might sometimes be less expensive to do let's say a transfer and death deed, where you might name your 2 children as beneficiaries maybe. But, if they don't work well together, maybe it's better to go through the probate process, because then you can put one person in charge of selling that home and taking care of that. And in the probate process, there are formalities that the personal representative must adhere to. So they're required to send an inventory of, a list of all the assets to the beneficiaries. They're also, at the end, will send a final accounting showing the beneficiaries, what were the estate administration expenses. So, even if a beneficiary isn't running the estate, they still are kept in the loop, and it's made known to them, how the estate was managed. So they are at least included in that information. It's not hidden from them. And I will say that's where, sometimes people, even though trust administration avoids some of that formality of probate, if there's concern about the parties getting along, they might like the oversight of a probate versus the trust administration where the court isn't involved. And that's why, another thing is, you're starting to, for people that might be thinking about, I want to, start doing a will or a trust, or thinking deeper into, what to do with my own estate plan. A big piece of that too is, don't just think about what your goals are, but also think about, what are my assets, making a list of everything you own. Where do you bank? Where are your investments? Where's your real estate? Do you own any assets outside of the state of Minnesota? And that'll help also decide, if there's a certain plan that may work better for you. And this kind of wraps up, my piece of this. But are there any other questions that we haven't addressed, or anything that you'd like me to dive into a little bit deeper?
I'm not seeing anything else in the chat that wasn't addressed, but certainly if anybody has any other questions, and if Kirsten has more time, we will be transitioning into our next breakout. But if Kirsten can stay around and people want to ask individual questions or stay in the room, as long as she's open to that, we can make that happen. Otherwise, at 11:30 here, we do have our next speaker, Ed Ussett. So thank you, Kirsten, so much. Great presentation. You see her contact information up on the screen right now. Be sure to jot that down if you want to follow up with her. And this presentation was recorded, so it will be available after the conference as well. So thank you so much, Kirsten, for your time and effort, and for presenting and being here with us. We appreciate it.
Yeah, absolutely. And I know it's